So one story that I mentioned at the top of the show here that is disturbing in so many ways is that the Fourth Circuit Court of Appeals has upheld a Maryland law on a ban on assault weapons. And the liberals are hailing it as a major test of new gun control measures passed in the wake of what happened in Newtown. And, of course, what we want to try to do is get you as much perspective on something like this as possible. It was hopeful that with the demise of Hillary Clinton and what she would have pushed on us from the left, that this thing was sort of water under the bridge, particularly with the Heller decision a few years ago. But we now know that that is obviously not the case. It's being challenged at several levels. Michael Hammond is our guest right now, Legislative Counsel for the Gun Owners of America. Michael, how are you?
How are you, Mark, and how are you, St. Louis?
Hey, good to have you back on the show again. We appreciate that. Absolutely.
Well, I'll try to continue your theme of Democrats galloping madly to the left, in this case with respect to guns.
Yeah, what do we know about the Fourth Circuit Court of Appeals? I mean,
we know that it was passed by Barack Obama.
There you go.
And Harry Reid, who was then majority leader, who essentially destroyed the Senate rules in order to put a bunch of leftists on these circuit courts, and they succeeded with the Fourth Circuit that meets in Richmond. By a vote of 10-4, the Fourth Circuit held that perhaps the most common gun in America can be totally banned, the AR-15. Probably more AR-15s around than just about any other single firearm. And the Fourth Circuit, meeting en banc, that is, the entire court met together rather than just in a three-judge panels, ruled by a 10-4 ruling that these were, in the words of Maryland's Attorney General, weapons of war which could be completely banned. Now, the first thing that occurs to me is I was in the military. As a matter of fact, I trained to be in the military in St. Louis. And apparently no one on the Fourth Circuit or the Maryland Attorney General ever served in the military, because I can tell you, the weapon I was issued was an M16.
Right.
And the thing about the M16 is it had a little selector switch that allowed you to fire it fully automatic. And I can tell you, I wouldn't go into a war. I wouldn't go into a firefight with a semi-automatic firearm. So if the Fourth Circuit thinks that an AR-15 is a weapon of war, it's because they have never served their country, at least in a meaningful way.
I have to wonder, 10 of these judges believe this, right? 10 of the...
10 out of 14 who voted.
Yeah, 10 of the 14 who voted. And I have to ask myself, clearly they're all intelligent people who graduated from law school at some point.
Well, I could say as a lawyer, you don't have to be intelligent to graduate from law school.
So my assumption is, even if you didn't, you understand American history and why the Second Amendment was put in there. It's pretty clear. When the people came out of the farm fields to fight in the Revolutionary War, the current weapon of war at that point was a musket. They all used muskets. I mean, this just flies in the face of what our founders intended for the Second Amendment.
And you would think the Second Amendment would protect the most commonly used firearm in America today.
Right.
And I can tell you, they've done studies. About 50% of the AR-15s are purchased for self-defense, to protect yourself and your families.
Right.
About 30% are purchased for target shooting. About 20% are purchased for hunting. But particularly women who like to fire like AR-15s because they have a handle on the top. They're really easy to carry, really light, and pretty easy to fire. So people who don't have a whole lot of experience with firearms find the AR-15 to be a firearm that they're comfortable with. And I think basically Maryland, when enacted this legislation prohibiting these guns, understood that. If you ban the guns that people like, presumably you can score a big victory against the Second Amendment. And I might add that Maryland, when it passed this law, a major gun manufacturer moved out of the state
Sure.
because it reasoned our employees won't be able to carry or possess the guns they're making.
So correct me if I'm wrong, but isn't this then?
I would never do that.
Isn't this just a challenge? I mean, this is going to be, I'm sure, sent to the Supreme Court at some point, and it'll be held up against the Heller decision. What's going to happen there? Any speculation?
Well, I can speculate. First of all, the Heller decision was a 5-4 decision that held that the Second Amendment was an individual right. Now, I said at the time, this is just the beginning of the battle. And since the Heller decision, there have been hundreds of decisions in district courts and circuit courts saying, yeah, it's an individual right, but it doesn't protect anything. And as a matter of fact, that door was opened by Scalia in his writing of the Heller decision when he wrote on page 54, there are a whole lot of permissible gun regulations which will be constitutional under this. My own thinking is that he wrote that page in order to get Anthony Kennedy's swing vote so they would have a 5-4 vote on the Supreme Court. Now, what happens when Scalia gets replaced by Gorsuch and Kennedy or Ruth Bader Ginsburg or Stephen Breyer, who are now around 80, get replaced by someone else? My guess is the Supreme Court becomes considerably more suspicious of anti-gun laws. And incidentally, I think that as Donald Trump has an opportunity to fill the vacancies in these circuits, which have been left vacant in the last couple of years, I suspect the circuits will be much more suspicious of laws infringing on the Second Amendment as well.
Michael Hammond is my guest from the Gun Owners of America. Michael, I have to ask, I would imagine a ruling like this is going to embolden some of these folks like the lady who is most likely going to be the next mayor of the city of St. Louis. She's leading the Democratic primary. They haven't elected a Republican here in 40 years. She's already got an assault weapons ban loaded into the Board of Aldermen. All it's got to do is be voted on, and it's ridiculous how far-reaching it is. I would guess people around America need to be on guard because these crazy libs on the left are going to come out of the woodwork trying to pass legislation like this.
Well, I'm surprised Missouri doesn't have a preemption law. I mean, it's now a constitutional carry state, one of the most pro-gun states in the country. If they don't have a local preemption law, they should pass one very quickly. But the courts have, this is just in line with what these Obama-packed courts have done for the last 6 years. They have upheld laws as crazy as New York SAFE Act, which essentially banned you from possessing most guns in New York.
Right.
And so under the circumstances, I can't say it was a surprise. Hope it's going to be reversed as Trump begins appointing judges. But for the last, since Heller, basically the Second Amendment has been a theoretical right, which in most cases has had no practical application.
All right. So this was a Fourth Circuit Court of Appeals decision. If that decision gets appealed, where does it? Does it go immediately to the Supreme Court?
Yes, it's an en banc decision,
Yeah.
yes. If the Supreme Court decides to take it, and the Supreme Court has discretionary certiorari review rights. So if the Supreme Court decides to take it, it will go to the Supreme Court, and presumably it will be heard by a Supreme Court in which Gorsuch will be the fifth swing justice.
Let's all include that in our prayers this evening before bed. My goodness. Michael Hammond, thank you so much. It's always a pleasure.
Thank you, Mark.
Yeah, you have a great day. Michael Hammond from Gun Owners of America, gunowners.org is their website, and really one of the premier organizations in America right now fighting for your gun rights. And this is scary stuff. That 10 people on this panel could argue that Heller does not include the right of people to own weapons of war. First of all, their assumption is that a AR-15 is a weapon of war, which it's not. And it lets them classify a whole bunch of any semi-automatic weapon then as a weapon of war in the minds of these crazy libs. I mean, this kind of stuff is frightening. That's why I want to try to keep you up to date on it when it happens, because it's just this ruling was just handed down. Now, hopefully, he's right. By the time we get around to this gets to the Supreme Court, you have to hope we have a Justice Neil Gorsuch up there who can kind of help us out. Hey, do you see this marijuana ruling? It wasn't even a ruling, but there's been an uproar in the weed community over what Sean Spicer said yesterday at his news conference. And we went out and we got a little bit of expert opinion on that, Liz.
Oh, you should be coming on pretty soon, dude. How much do you smoke?
This will be a little demonstration of that. Listen up. That was my skull. I'm so wasted.
Spicoli is particularly upset that the administration may go after legal weed in some of these states. We're going to talk about it up next. 314-9